Hello, my name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about a case that is in the U.S. Northern District of California against Meta, and it's about the Meta Pixel. So I think this case is called John Doe versus Meta. It is a case about an individual suing on their behalf and also the behalf of other people like John Doe who, for example, let's say they use a hospital website. If they use a hospital website and the hospital uses a Meta Pixel, those pixels can sort of call back and tell information about an individual. So it's not as simple as saying, okay, someone read, 100 people read my newsletter or something like that. The Meta Pixel has the capability of being able to report a lot more information about someone. So like, let's say you go onto a hospital website, you fill out a form for a particular appointment. It may capture sort of when that appointment is, maybe the information that you entered into a form. And this case is saying that they think that this Meta isn't being transparent about how their pixel is being used, especially around protected health information. So this particular case, they think it implicates HIPAA. So obviously Meta isn't a medical company, but if they handle data of people in this type of context, they would be considered like a business associate. So for example, a hospital will be a covered entity. In this case, they think that Meta should be considered a business associate. And if they are a business associate, there are certain rules and regulations that they will have to follow as a result of this. They also think that this implicates the Electronic Communications Privacy Act, which is federal, the California Invasion of Privacy Act. They think it's unfair competition, and also it goes against the good faith and fair dealing on Meta's part. So there's also a sister case going on against Meta as well. It's called Jane Doe versus Meta, and it kind of circles around some of the same issues. But I think in the Jane Doe case, this person was saying that they had actually received advertising from Facebook based on some of their protected health information, and they believe that the only way that they would have known that is based on these pixels that some of these hospitals use. So I think in this particular case, these cases, they were saying that they tested hospital websites, and like up to a third of them use this Meta Pixel, and that they think that there should be obviously some type of penalty, some type of redress, and they're looking to create a class action lawsuit as a result of this. So I think, this is not the first, and this won't be the last case of this sort. It's pretty interesting. There have been situations where companies have used pixels or other attributes. For example, maybe accessibility features to assume or infer maybe someone's disability, and then advertising to them to that disability, which may be against, not transparent. It may be against a lot of different rules, but I'm really interested to see if this ever turns out to be a class action. I think there are a lot of things they're claiming here. I think these claims may end up getting trimmed down, and it may actually end up being a class action. But I think this is probably a very common thing around not just pixels, but also kind of accessibility features and how people can be identified for marketing purposes based on other things they do on their computer or types of things that they have installed. That's it. Thank you.